All rise. Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Welcome to the Court of Appeals. This is Court of Appeals number CACV150083. For the party's information, these proceedings are being recorded, and each of you will have 20 minutes. So as you approach the bench, if you will let us give us your name and who you will be representing. The recordings will be both audio and visual, and hopefully, if everything works, you will be on YouTube. Appellant, you have you may reserve a certain amount of your time for rebuttal, and if you choose to reserve a certain amount of time, if you'll let us know, we'll try not to horn in on all of your time. And with that, we may begin.
Good morning. My name is Michael Gurian. I'm appearing this morning on behalf of plaintiffs and appellants, along with Bert Rosenblatt. And I would like to reserve some time for rebuttal, and I guess I'll know that when I hit it. So I'll advise the court of that. The issue in this particular appeal is duty. The question is whether the defendants, and just for shorthand, as I did in the briefs, or as we did in the briefs, I'll refer to the defendants under the collective of Reynolds. The question is whether defendant Reynolds owed a duty of care to the decedent in this case, now deceased Dr. Quiroz. There are two sources of the duty of care in this case. One source is the common law duty of a possessor of land, and the second source of the duty is the general duty to not engage in conduct or create situations that pose an unreasonable risk of harm.
Third, Section 7.
Well, as beginning with Ontiveros' case,
later, yeah.
Right, then Gibson, and then Gibson's reference to the restatement third.
Well, Gibson's reference to the restatement third, though, is that we haven't adopted it.
Well, true. In Gibson, they did not expressly adopt it. In fact, they indicated that they didn't have to yet address that question because there was a statutory basis for the duty in that particular case. The court clearly, though, did not express any disapproval of it, and in fact did state that one could conclude that persons do owe this general duty of care.
Although Justice Hurwitz pointed out that adopting it would represent something of a sea change in what had been Arizona common law for quite some time.
There was that reference in that portion of the Justice Hurwitz's commentary. I think that change is ongoing. I do think, looking at the development of the law and the statements of the Supreme Court from McCarver through Gibson, talking about sort of the erosion of the relationship-based test elsewhere as well as in Arizona.
I mean, you could argue that there's a problem with Gibson, or many problems with Gibson. I know that many, it's been a controversial case. But given its statement and the fact that it's currently good law, given its statement that the court is to pick and choose duties based on public policy or relationships, wouldn't adoption of Section 7, which is so broad and all-encompassing, essentially moot the job that Gibson assigned the courts?
It would establish a general duty of care, which...
And so we as courts wouldn't be engaging in the type of analysis that Gibson directed us to, which you might argue is a sound direction to go, but not the direction that Gibson went.
In that particular case, no. Is it the direction that they're hinting or suggesting at when they state that one could conclude that people have a general duty? Yes. Now, and I'll also note, there were other references to Section 7 of the Restatement Third in the Gibson case. For example, Gibson jettisons foreseeability as a factor in the duty analysis, citing the restatement third, section 7, I think it's comment J, where the drafters of the restatement say, we don't look to foreseeability in determining duty. So I do think maybe it's slow, glacial, that's the typical pace of the law. It may be moving that way. I don't, and that would obviate the existing paradigm for duty. It may be going that way. I think it is trending that way. Certainly there are a number of other jurisdictions that have either a similar analysis with some other elements or that have adopted, at least as in Gibson, I think there were 2 that were noted in a footnote, or maybe it's not Gibson, or maybe one of the later cases, Court of Appeal cases, that looked at the statement in Gibson. I think it was Wickham. Diaz also looked at that, considered duty in light of those statements by the court. But certainly it wouldn't eliminate the role of a court, because as Gibson did state, that a general duty of care, such as that set forth in Section 7 or as stated in Ontiveros, would be subject to any exceptions that would be advisable based on policy.
It would invert the role of the court, as defined in Gibson, from being a creator of duty to a destroyer of duty, if you will.
I wouldn't say a destroyer. It would be making exceptions.
I was being a little hyperbolic for convenience, but yeah, instead of saying they're picking and choosing where there is a duty, the courts would suddenly be picking and choosing where there isn't a duty.
Correct. Duty would be the default.
So we would, if we were to go in this direction to find a duty, then we would have to suggest that Gibson is past its prime.
Well, I think you could say Gibson is going in the right direction in that footnote 4. That is and that's not out of left field in Gibson, because Gibson cited to the court's earlier statements in Ontiveros, 25 years or so earlier in 1983, looking at that proposition, which is not a position that's not accepted, in other jurisdictions. Certainly, but I want to make clear I'm not staking my claim primarily on Section 7 or Gibson or Ontiveros. That's a secondary basis for the duty in this case. The primary basis is the duty of a landowner or a possessor of land.
And then the obvious rejoinder to that is your client, or the decedent in this case, was never an invitee of the defendants.
Correct. He was not an invitee. He is not a business invitee, a trespasser. He's not one of the categorical relationships. There is no categorical relationship that existed between Reynolds and Dr. Quiros. And in fact, in the reply, I make that very clear. We're not arguing any pre-existing relationship.
So if for example, we have a peanut factory here in Phoenix, and you have an employee who works at the peanut factory, has peanut dust all over his clothes, and then goes to dinner with a friend who has a peanut allergy, would the landowner's duty extend to that friend with the peanut allergy?
Yes, if the landowner or the land possessor's conduct on its premises creates a risk of harm or injury or physical harm to that person off the premises. That's the duty.
The existence of peanuts creates a risk of harm to those who are allergic to them. And so would you extend that then to one who serves peanuts as snacks in their home and enables enough of that dust to contact another person?
Well, I mean, you could certainly substitute asbestos for the peanuts and
Well, I bring it up only because it's a little bit more common, but it seems to invoke the same. I mean, people don't serve asbestos generally in their homes, and asbestos is now a highly regulated substance. Your approach, I think because of the age of this case, omits the idea of regulation of hazardous substances entirely, right?
it generally the exposures predate, for example, even OSHA.
Of course, and so I understand why you wouldn't rely on that. So I'm sort of trying for my hypothetical to come up with, I chose peanuts, you can choose something else that is essentially non-regulated, but could be hazardous.
Correct.
shellfish. There are a number of substances that could cause great harm to people through secondary exposure, and yet the duty of a landowner seems perhaps ill-fitted to those potential victims.
Well, the duty here, or at least the facts here, are that it's not simply someone who's being served peanuts, but I believe your hypothetical was a manufacturer of peanuts.
Manufacture but there's plenty of dust.
Correct.
In sufficient quantities to injure certain vulnerable people. And that dust could be present on the clothing of a worker, a social guest, any number of people who perhaps are just unaware of the danger they might pose to a vulnerable person.
And I agree with that there is a duty there. If a manufacturer or a landowner or a land possessor in the operation of its business is using a harmful substance, a toxin, something that poses a risk of injury to individuals, not only on the premises, but off the premises as well, then a duty of care exists. That doesn't mean, though...
Substance, though, even if it's unregulated, you would say this applies to any such substance.
Yeah, I would say the regulation is not some sort of litmus test as to whether there would be a duty or no duty. Certainly, and...
Well, I understand why you would say that in this case.
Pardon?
I understand why you would say that in this case, of course, but for the future development of the law, if we're dealing with hazardous substances, wouldn't a better touchstone be the use of hazardous substances in conformance with or not in conformance with regulations?
Well, if you're using substances, let's assume it's a heavily regulated substance. If the substance is being used in violation of those regulations, then certainly that would be evidence to come in as to breach. Mm-hmm. For the fact determinations made with regard to that. But wouldn't it be a better
surrogate for duty? Because now we know that public policy says you shall not use lead in certain ways, for example, or asbestos. If once public policy says that we recognize this is dangerous and you've got to take certain care, that would seem to me to indicate clearly under the Gibson analysis that there is a duty.
That's true, because in McCarver, and in lots of cases, the courts, the Court of Appeal, the Supreme Court has stated that public policy can determine whether a duty of care exists. And public policy can be founded in the common law, can be founded in statutory law, it can be founded in regulations promulgated pursuant to statutory law. Certainly that could be a basis for that. That's not to suggest that asbestos was completely unregulated during the exposure period here. There were laws and regulations, but the heavy regulation that existed beginning in 1972 or so with OSHA didn't quite yet exist.
But are you yet arguing, or are you arguing now that the existence of heavy regulations implies that there should be some special recognition by the courts of a social policy for a duty with regard to asbestos that might not exist for peanuts? Or are you really equating asbestos and peanuts in my hypothetical?
No, I'm not suggesting that heavy regulation is sort of the threshold for determining duty. I was interacting with regard to the hypothetical that
Understood.
That was presented.
Well, I was just wondering, if you were arguing that there was perhaps some heightened ability to recognize a duty when heavy regulation exists.
Yeah, I'm not sure. I would say that would it can be viewed as a source for the duty. If there are laws regulating a particular substance or particular conduct, a court can look to that particular law and determine that, well, there is a duty of care here with respect to civil liability.
What would you say with regard to a healthcare worker who's exposed to infectious disease and leaves a hospital, for example, with some infectious material on his or her clothing? Same analysis?
I agree with the same analysis. It doesn't. Our position, our analysis is not dependent upon the type of hazard or whether the location of the hazard. Now, maybe the legislature steps in and says, well, because of the necessity of having hospitals to care for sick and injured individuals, we're not going to allow sort of the liability when someone is infected or, say, a worker is exposed to a particular disease and they take it home. and resulting in exposure to family members there, and they contract. The legislature can step in certainly and say, well, the healthcare context is something that's very different and that's necessary, and we don't want to have hospitals going out of business.
Well, it could, but it hasn't. So,
no,
so
it has
you're
not.
suggesting that the current state, I mean, that would sort of, that would resonate with this floodgate argument, because suddenly lots of people who get the flu would become potential plaintiffs if they happen to know a doctor or a nurse. Is that really where you think the law is today?
I think the law is there certainly with respect to asbestos. Now, we can come up with the outlier hypothetical to have that sort of horrible situation that would countenance or that would advise against a duty of care. But I don't think that's practical. We don't look to the outlier situation as a basis to deny a duty that's otherwise justified. And you mentioned the proliferation of claims or the flood of litigation. And as we wrote in our opposition, there is no evidence of that flood. This is sort of the typical and usual boogeyman that's thrown out there against a duty of care. And I'm not saying a bit tongue-in-cheek, but I see it a lot. And there are jurisdictions that have recognized a duty of care. And as we pointed out, if there is this flood that has occurred in take-home asbestos injury claims, there would be evidence of it. There would be some suggestion of it, at least from those jurisdictions, and that includes Washington, that has a heavy asbestos docket based on the naval presence in Puget Sound, Louisiana.
You may be right, but it sounds like the entire theory underlying your argument here, which I appreciate, is that we should not be crafting an asbestos rule. We're looking at common law tort principles that may apply to a number of different substances. There's nothing unique about asbestos in the context of the duty you're urging.
I agree with that, and I'll sort of turn it around, because I'm in no way suggesting that that's what this court is thinking, but in other times I've made the arguments on this issue, I get the feeling that there otherwise would be a duty of care, but there's a special rule for asbestos because of all the baggage that comes with this litigation, that, well, we have a rule of duty, but we don't want to have it in asbestos claims because that's going to lead to this flood of litigation, and it's political.
I don't think that's part of our discussion.
No, but I'm saying it could be turned on its head, which is why I'm not arguing for some specific rule for asbestos. This is a duty that's founded in the common law duty that a landowner has. And we cite to the Burns case, Burns versus Jacquet's Mining Corporation, where the defendant operated an asbestos mine, had a tailings pile, that asbestos from the mine was swept by the wind to a neighboring trailer park, resulting in contamination there and property damage there. There was a suit that was brought. And one of the holdings was, well, no one is yet sick, so you can't sue yet. We have to wait for a manifestation of the injury. But once that occurs, Arizona follows the delayed discovery rule. Or
correct me if I'm wrong, but wasn't the theory there nuisance and not negligence?
That's one of the claims. There was a negligence claim in there as well. There were 4 causes of action. I think negligence, gross negligence, nuisance, and strict liability. And the court said you're premature on your claims of physical injury because no one has yet manifested a physical injury yet. No one is sick yet. You may have subclinical injury, but that's not enough. The court did recognize and said you can have nuisance damages, you can have medical surveillance, and when the time comes, if somebody is sickened, if somebody does manifest that asbestos-related disease, then based on the discovery rule, you can in fact sue. And in that particular case, those are people off the premises. They're not on the premises, and that's where the conduct of the defendant on its premises, how it used it and maintained it, resulted in certainly those nuisance damages and the possibility for future claims based on negligence if these people got sick. And I don't see, there is no principal difference in my mind between asbestos being taken by the wind or some other environmental factor and swept to a neighboring neighborhood right next to it, or even a mile away, or 3 miles away, or a fire started on someone's premises and having a path of destruction 10 miles long. There's no difference between that and where the employee carries it unwittingly on their clothes home to their family.
So it might be an interesting discussion in itself, but your time is running low, and I don't want to deprive you of it.
I'll reserve my remaining time.
Okay, thank you.
May it please the court, good morning. My name is Edward Slaughter. I have with me Brandon Maxey of the law firm of Hawkins, Parnell, Thaxton, and Young. We represent the Reynolds defendants in this case as they've been described. I would be remiss if I did not begin by saying thank you to the court and thank you to Mr. Gurian for graciously agreeing to postpone this argument while I was in trial. I deeply appreciate that courtesy and professionalism. It does not go unnoticed. This is a very important case, but I believe all of the questions raised by it have already been answered. The Arizona Supreme Court in Gibson gave us the rubric with which to analyze whether or not there would be a duty in a case like this. And they did so pretty simply, I think. The court started first by saying foreseeability is not an issue that we will consider in deciding whether or not to extend a duty. That's important because it is different from all of the courts in other states who have found that there was a duty in a similar circumstance.
It is a somewhat unique approach that we have, but Gibson also left the door open for courts to discover duties as a matter of social policy. And when you have parties who are using known toxins in massed quantities, might that not be a place where we could anchor or should anchor a social duty?
I think that the Gibson court certainly recognized that it's the function of this court to identify duties that exist. And the question is, how do those duties come into existence? The Gibson court articulated two ways that that could happen. One, duties come into existence by statute. So just as Your Honor indicated in previous questioning, regulations could have been promulgated. If there were statutes, codes, regulations, or anything of that ilk that had been created back in the time frame where Mr. Quiros worked at the Reynolds plant that they could point to, that could potentially give rise to a duty.
Well, that could give rise to negligence per se if they violated the statute. But knowing now what we know, that state and federal legislatures have rather aggressively targeted asbestos as a substance that needs to be regulated, isn't that enough for us to infer that a duty as a matter of social policy should exist? I mean, we're not talking about the breach of a regulation, but we're talking about the collective recognition by legislative bodies that there's a need for regulation.
The problem with that approach, Your Honor, would be that you have to look back 50 years. So business here in the state of Arizona should be allowed to expect to do business under the standards that exist at the time. In the 1950s up to 1970, plaintiff's counsel, appellant counsel points to no regulation that existed. So Reynolds was operating its plant 100% in compliance with the law as relates to this case. So I don't think that we want to send a message to business in Arizona that you can be operating your business in a 100% lawful way, only to find that 50 some odd years later you may be hauled into court and have a new duty recognized or created where no regulation existed. So I think you would have to be able to point to a regulation that existed contemporaneously, and none exists, certainly none has been pointed to. Next, beyond that, the regulation or statute would have to be one that was designed for the purpose of protecting the class of people at issue, like a person in the home of an employee. So there's certainly nothing like that exists. The reason, and that goes back a bit to, I think, the reason the courts here have rejected foreseeability as an issue to look at, because that conflates the negligence and causation issues with duty. When you have to take a look back in asbestos cases, as we always do, you're always asking yourself those questions about foreseeability. They would be an issue in a trial, but they can't create the duty to begin with.
Well, why is that? I mean, I understand that Gibson says what it says, but if I were the hypothetical reasonable man from tort law trying to order my affairs, wouldn't the best way to be to predict what my duties are going to be, wouldn't the best way be by reference to what I can foresee might cause others harm?
I certainly think that in some states they've decided that that's almost the whole ball of wax. I think here in the state of Arizona and other places, foreseeability has been separated out from duty. foreseeability still exists. It's still an element of a tort that you would have to prove here. So you're still looking to what may be foreseeable, but that's a very elusive thing. It's trying to catch a salamander with bare hands.
But as a non-lawyer, citizen of Arizona, just trying to figure out how not to get myself sued, how do I know what my duties are?
I think very simply, the state of Arizona has articulated standards. So if you're running a business in the state of Arizona, there are workers' compensation laws. There are statutes about the use of materials and products on a premises. There's a whole body of duties that have been created by the legislature. Then in addition to that, there are relationships or special relationships or categorical relationships that have been identified by the courts. So that's the way you know. You look to those duties to determine what your conduct should be. And if a company that is operating for the good of the state of Arizona or to the good of the state of Arizona and its people is doing so in a lawful manner, making products, creating jobs, invigorating the economy, and following the law, they ought not be expected to be hauled into court for something like this some 50 or 60 years later. The other thing that Gibson articulated is this notion of a relationship or the nature of the relationship. I think that does give the court the ability to identify a relationship that has not previously been identified, but there's none here. There's nothing new or unique to be identified. There is no categorical relationship. What appellant calls on this court to do is in direct contravention with Gibson. Appellant says their two main arguments are adopt Restatement Third, which has never been adopted in the state, or to say that the conduct that Reynolds engaged in created a duty. The Gibson court could not have been more clear. I know that you certainly have access to this, so I won't read the whole thing to you, but I think it's telling. The court said, quote, an attempt to equate the concept of duty with such specific details of conduct is unwise because a fact-specific discussion of duty conflates the issue with the concepts of breach and causation, citing approvingly the Coburn case. That's exactly what appellant is calling on you to do here today, and that flies in the face of Gibson. It would directly contravene what the Arizona Supreme Court has said about how you articulate a duty. So the next element or analysis is one of public policy, and you have to weigh the good versus the harm or the risk and whether or not there is a need here. There is no need here. There is not a need to create yet another avenue for plaintiffs to pursue money in asbestos litigation. In this very case, plaintiffs had the ability and did sue product manufacturing companies who supplied asbestos-containing products. That is unchanged. There are, as anyone who's watched television knows, some $30 billion worth of asbestos bankruptcy trusts available. There are many, many avenues already available to a plaintiff like Mr. Quiros without creating a new duty. Does that open a floodgate if you do? I think that it is fair comment to say you're not going to see 5,000 new household exposure asbestos cases roll into the state of Arizona, and I don't mean to suggest that you will. But, and I'm not being trite about this, one more asbestos case in Arizona is one more too many. They take massive amounts of resources. I am, as I think the court knows, in the middle of a 7-week trial. I had to take a day off of to come here, and I think that judge as well. Those cases are raging all over the country on more and more attenuated theories, and they take massive amounts of resources that are unnecessary. There's no reason to extend that. And I think the justice is well-founded in the concern, or at least identifying the potential, that this would not be a new asbestos rule. This would be a new duty generally. That I had not thought of the peanut situation, but whether it be peanuts or any other substance that could cause someone an illness, you would be extending that duty to everyone in Arizona potentially could have a claim for some sort of secondary or tertiary exposure like that. That could open up just a whole can of worms that would be a massive explosion of potential litigation. And there's no good reason for it. Unless you have any further questions, I think I've said enough.
Thank you.
Thank you.
Very briefly, there is no claim without an injury. That's the Burns case. So if somebody's merely exposed to asbestos or peanut dust, if they don't have a manifested injury, there is no lawsuit. The argument that one more asbestos case in Arizona is too many, Dr. Quiroz had all of his asbestos exposures in this state. This is where he was sickened. The argument that there is too much litigation is essentially the defense bar's claim that we sicken so many people that there is so much litigation that it has to come to an end. The proliferation, if it exists, and I don't think it does, with respect to those people who are truly injured, is a direct result of that use of asbestos. And to say that, well, you can go after bankruptcies or other defendants or other sources, that may be true, but that doesn't absolve other tortfeasors of liability. Those are sort of the policy arguments.
No, although I think it would put us in a very dangerous place if courts were to decide cases like this based on whether they think there should be more or less litigation of a certain type. I don't think that's our business.
I agree with that, but some
So
courts...
sympathy or hostility to litigation really doesn't form part of our analysis.
Absolutely true. But some courts have pointed to that, the proliferation of claims to say, we're going to bar that, we're going to stop that. And I agree. I don't think that is a proper consideration, particularly here in Arizona, but I don't think there actually is a proliferation. There's certainly nothing in the record to suggest that.
Maybe the concern isn't proliferation of claims, but if duty is intended to be some sort of a limiting principle, is there a limiting principle to the position you're taking?
Well, the limit would be as to, first of all, you need to have an injury, and secondly, you need to have the evidence to prove the breach, the causation, and the damages. It's not simply duty equals liability. Far from it.
How, if you were writing restatement fourth, how would you phrase the duty here? Because it sounds to me like what you're arguing for is a secondary exposure duty regardless of the hazardous substance. And
well,
that's pretty broad.
I wouldn't phrase a duty in terms of secondary exposure. I would say, I mean, if it was truly me personally writing it, I like the restatement third's definition of duty. I think that individuals or corporations have a general duty of care not to engage in conduct that creates an unreasonable risk of harm, leaving courts with the ability to create exceptions to that if I was personally doing it. I know Arizona's not there yet. It may be trending there, or maybe it's not. Maybe the Supreme Court will take a case up and put that one to rest. But I wouldn't classify, I wouldn't term or phrase a duty in terms of secondary exposure. I would phrase it in terms of, with regard to a possessor of land or anyone else, that you have a duty not to create an unreasonable risk of harm. That's particularly true with the premises liability law. I don't think that's a controversial.
It's all about foreseeability.
Well, no. In fact,
if you have a duty not to create an unreasonable risk, isn't risk analysis inherently intertwined with foreseeability?
Well, this sort of gets back to what you mentioned earlier, that it's sort of all intertwined together, and maybe we're all fooling ourselves. In Gibson, the court said, well, maybe when courts employ foreseeability, it's a disguise for making these decisions that juries should be making. And other courts say, well, foreseeability in the duty context is different. It's not the same sort of in-depth inquiry that you look at when looking at breach or causation. There are these sort of philosophical, metaphysical sort of arguments that do go on amongst the courts. But the restatement third drafters I know, and I understand that there hasn't been an adoption, at least of Section 7. We pointed out also Section 54, dealing with the duty of a possessor of land. But the restatement third dropped foreseeability. And Gibson cites to that as support for its conclusion to drop foreseeability. So in Section 54A of the third restatement, there is no foreseeability in there. And the rule in that provision is that a possessor of land has a duty not to have artificial conditions or conduct on its land that poses a risk of harm to persons or property not on the land. I think that is a succinct and accurate description of the duty I'm talking about, and I don't think that is certainly not contrary to existing Arizona law regarding the duty of care of a possessor of land. I cited the court to the Burns case. We cited earlier to the Udi case, to Presiding Justice Jacobson's concurrence. I don't think it's the law that a possessor of land can do anything on its land that it wants without concern or potential for liability for persons injured off the land as a result of that use of the land. The fire example.
Well, that's why we have nuisance, right? But I think we're out of time, yeah.
Okay. Thank you for your time. It's always enlightening discussions, these issues.
Thank you very much. We will take this matter under advisement, issue a ruling in due course, and we are adjourned.